Kicked out? You have rights.
Just knowing that just because I'm served and says that I need to turn over the property, I don't have to turn it over immediately. There is a process. I can still go to court and plead my case. If there's any maintenance issues that I have been requesting to be fixed and they weren't fixed, but then I received court papers, I now know that that's retaliation. I can fight that in court.
You don't have to live it to learn about it.
My bathtub is leaking or my dishwasher isn't working. So until that's working and the landlord's not doing anything about it, I'm not going to pay my rent. And I absolutely understand that reaction, but that is absolutely probably the worst thing you could do in that situation, because what it does is turns the landlord into the one that is violating and not living up to their obligations, into the tenant doing that. And now it gives the landlord a legitimate legal reason to evict.
I'm Erica Bryant, and this is the Tenants Toolkit, a 7-part mini-series created to help those who may find themselves facing eviction understand their rights and what they can do to stay in their home. Because if you're facing a housing-related crisis, you aren't alone. Here in Charlotte, rapid growth has created a shortage of affordable housing options, and the Tenants Toolkit is here to help. In this series, you'll receive a step-by-step guide to finding, budgeting for, and staying in your home long-term. This episode focuses on tenant rights.
My name is Brett Shockley. I'm an attorney with Bank of America in the legal department. Earlier this year, I spent 3 months with legal aid representing tenants that were facing eviction.
Equal access to justice is the mission of Legal Aid. It's a nonprofit law firm that provides free legal services in civil cases to people in need. They emphasize that all people with or without an attorney should read their lease before signing it.
I think that the lease is going to really govern the responsibilities of the parties, but the landlord can't disclaim responsibility for fixing the apartment. And so even if the lease says, hey, I'm not going to, you're responsible for all maintenance, repairs, et cetera, the landlord has to comply with the housing code and provide safe and habitable premises. And so no matter what the lease says, the landlord has an obligation to make sure that the property is safe, fit, and habitable.
Tenants are obligated to pay their rent.
Right. So leases, that is the controlling contract in any relationship between a landlord and a tenant. And you're right that a lot of times people, when they're handed a lease, they don't read it and they sign it, and they don't always know all the terms that they're agreeing to.
Isaac Sturgill works for Legal Aid.
I supervise our housing unit. So what my job is to try to help tenants that are going through eviction proceedings avoid evictions, and to try to help people who have housing subsidies keep their housing subsidies. Tenants are protected to a certain extent by the law, even if the lease is incorrect or written badly. So one example of that is that tenants in North Carolina have the right to have repairs made by the landlord, and the landlord has to keep the house up to certain minimum standards of fitness, and it has to comply with the Charlotte Housing Code, for example. No matter what the lease says, those protections apply. So even if the landlord writes in the lease that the tenant is responsible for all the repairs and that the landlord doesn't have to do anything to fix the place, even if the lease says that provision is going to be void as a matter of law, and the landlord is still going to have to make repairs and fulfill those obligations. That's not something the landlord can get out of by putting that in the lease agreement.
If something breaks, a tenant should call the landlord. If the landlord doesn't fix it, a tenant can then call 311 to get code inspection with the city involved.
As soon as a tenant recognizes a repair issue, I think one of the most important things to do is to reach out to the landlord to make them aware of it. And the best way to do that, planning ahead in case there are issues with it, is to do it in writing. Email is a great way to do it, and you'll have a record of it. Because if it does ever end up in the eviction process where the tenant wants to raise the condition of the property or the fact that the landlord hadn't fixed repairs, one of the things you have to show, one of the things the tenant has to show, is that they provided notice to the landlord, that the landlord was aware of these defects, these repair issues. And so oftentimes, the tenant can testify and tell the judge, that they told the landlord, but it makes it a heck of a lot easier and more convincing if there's sort of an irrefutable document or email that says, from the tenant to the landlord explaining this on a particular day. And if they don't within that time period, they're going to get fined a certain amount per day until those things are fixed. And once they're fixed, the landlord then has to call the city inspectors to come out and fix and they will sign off and say, okay, everything's now been fixed. So, I think talking to the landlord is step one with any repair issue, documenting that you did that or that you told the landlord about it. And if that doesn't get you anywhere, calling 311 to get a code inspection report will require the landlord to do it. They don't really have a choice at that point.
There are some laws out there that protect tenants for that very reason. Even if the landlord tries to put a clause in there, for example, that says that the landlord doesn't have to make any repairs and the tenant has to make repairs, that's not going to hold up in court. If the landlord doesn't make the repairs, even if the lease says they don't have to, as a matter of law, that's not going to hold up. The same thing with illegal fees. So some leases, there's limits on the amount you can charge for a late fee, for example. The lease can say that the landlord gets a $100 late fee if the rent is late, but if that amount is more than the amount allowed by law, that provision will be void. And so if a judge sees that and they see that the late fee is more than it's legally allowed to be, they should not allow the landlord to collect those fees. And in fact, the tenant may even have a claim against the landlord in a situation like that for the landlord trying to collect illegal fees from the tenant. The tenant may even be able to get civil penalties against the landlord.
These attorneys say if you ever do go to court, bring 3 copies of your documentation. For example, 3 copies of the emails you wrote asking for repairs, or 3 copies of the landlord's email or a transcript from the landlord's voicemail saying you have to pay a late fee of $100. Knowing your rights as a tenant starts with your lease.
It's also important just to read your lease and know the rules. And the 2 ones we just talked about are probably the biggest 2 illegal lease provisions to be on the lookout for. One is anything that says that the tenant has to make all repairs and that the landlord is not responsible for making any repairs. Anything like that is not going to hold up in court. And then just be aware that there are certain caps on the amount of fees that landlords are allowed to charge. Late fees, for example, the landlord can charge either $15 or they can charge 5% of the monthly rent, whichever one of those is bigger, but they can't charge any more than that. And if their lease says that they're allowed to charge more than that, that provision is going to be void, and the tenant may very well have a claim against the landlord for unfair debt collection practices.
And if you tell the landlord something needs to be fixed, they can't kick you out because you asked them to fix it.
That would be an example of a retaliatory eviction. A lot of times, and that's a defense. So if you have an eviction case filed against you where your landlord's doing it in response to you complaining about repairs, for example, that's a defense that you could raise in court. And if the judge agrees with you and the judge says, yes, I do think the landlord did this in response to you complaining about repairs, that should result in the entire case against the tenant being dismissed at that point. A lot of times landlords, if they do a retaliatory eviction, most of them are, intelligent enough not to say that's the reason why. So they may give some other reason or they may give no reason at all. And then it's kind of on the tenant to convince the judge that that's the real reason why the landlord's evicting them.
Sturgill says that's why documentation can be so helpful to show the tenant asked for a repair on this date, and shortly afterwards, the eviction notice was given. Keep a record of any conversations with your landlord. And remember, emails and written communication are the easiest way to have a record of your conversations.
If there's any maintenance issues that I have been requesting to be fixed and they weren't fixed, but then I received court papers, I now know that that's retaliation. I can fight that in court.
Attorneys aren't the only ones familiar with the eviction process. Kimberly has gone through the process more than once.
It's just a lot. Me personally, I never, ever sleep. It was more so of my body is just laying there, eyes closed, but my mind is everywhere. Like I could hear my thoughts as I'm supposed to be sleeping. Like, okay, this is due. How are you going to pay this? Or what if you do this? Or can you reach out to this person? Or now I got to go to work and say, I need this day off because this has come up, but you don't want to tell too much of your business because you're afraid, you're ashamed. And it's just a lot.
The good news is you don't have to figure this out on your own.
My name is Tiffany Bost. I am the Director of Economic Mobility here at Crisis Assistance Ministry.
Information and advice can come from various sources, and it can make all the difference when you use it. Tiffany Bost remembers one tenant who read her entire lease and found a big red flag.
She remembered, and I never forget the day she walked in, and she wanted to let me know that, Miss Tiffany, y'all work with me, and you helped me to find housing, and I had to move. Unfortunately, I was evicted, but I found another place, and this landlord, it was trying to get me to sign all this paperwork, and I remembered y'all telling me I needed. She said, I told him, can I take this lease home and look over? And she took it, and she studied it. And in the lease, it had talked about repairs that needed to be done. Okay, you will be held responsible. It was like an 18th page. Okay. And so she found it, and she was able to go back and talk to the landlord about it. And he was like, oh, I didn't mean for that to be in there, this. And she said, well, you know what? Can you scratch this? She said, I remember y'all saying if he scratches it and initial it and makes a change or give me a new one. And he did that. Okay. But he was shocked that she found it, I think. And she was able to get him to negotiate, take that out of her lease. And she's now in housing with her children. And it made me happy because she was aware, and she used that awareness to change her situation. So she and her children are housed. And it's affordable.
Knowledge really is power. Knowing your rights as a tenant can prevent years of struggle and frustration. Knowing what is legal and what isn't can prevent you and your family from being evicted illegally. While it may seem like the playing field is tilted, spending some time reading your lease and documenting your interactions with your landlord can only improve your situation. I'm Erica Bryant. Special thanks to Brett Shockley, Tiffany Bost, Isaac Sturgill, and Kimberly Timmons Hampton for lending their perspective and expertise. For links to the resources mentioned in this podcast, go to thetenantstoolkit.com. In the next chapter of the Tenants Toolkit, we continue our focus on tenant rights.
To the tenants facing the issue, $800 sometimes may as well be $8,000 or $8 million. If they don't have it, the dollar amounts may not seem huge, but they can be insurmountable pretty quickly.
The Tenants Toolkit was made possible by the Charlotte Executive Leadership Council and Foundation for the Carolinas in collaboration with the Queen City Podcast Network and Balto Creative Media. From Foundation for the Carolinas, producers are Hillary Crittenden, Jennifer Morlew, and Katie Koff. From the Queen City Podcast Network and Balto Creative Media, this series was produced by Brian Baltashevitz, written by Pamela Escobar and Meredith Carter, engineered by Sarah Pollock, and edited by Kanata Edwards and Elizabeth Egan.